5 common workplace lawsuits and how to avoid them. Workplace lawsuits are unfortunately part of the risk continuum an entrepreneur must cope with when he or she decides to start and run a business. As a small business owner, you don't have to know the ins and outs of the law per se, but you should become familiar with the key guidelines applicable to your sector, business, and commercial activities in general. To be less susceptible to workplace lawsuits, try to stay up to date regarding the multiple state and federal laws that affect your company. Welcome back, folks, to another edition of the Sweetie Kiwi Show. How you doing today? I hope you are doing fantastic. I'm doing marvelous. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about 5 common workplace lawsuits and how to avoid them. Before we get into the nitty-gritty here, a few things you should know. Now, disclaimer here, this video is intended to be informational. This is just a general information only. This is FYI, nothing in this video constitutes legal advice. So if you have a particular situation, I would advise you to consult with an attorney or a legal expert before making any legal decisions. Now, you don't have to know the law, but it is very important to familiarize yourself with its general guidelines, especially as those guidelines pertain to your particular sector. Now, discrimination. Discrimination is the number 1 common workplace lawsuit. Unfortunately, discrimination is another common type of workplace lawsuit. So an employee who happens to be a member of one of the following protected classes can file a suit against an employer if he or she has been treated unfairly. Now, what are those federally protected classes? There are several. I'm going to give you a few of them here. This list is not exhaustive because Congress constantly changes or updates the law. So you have gender, race, color, national origin, age, disability, religion, veteran status, pregnancy, citizenship, familial status, genetic information. Besides, you also have state law protected classes. Now, this varies from state to state, which is pretty normal. States have been very good at following what the federal guidelines say, but in some states they have added some, I would say, some clauses, some specific clauses. So some state law protected classes include sexual orientation and marital status. Now, so what I'm trying to say here is that whenever you hire someone who is part of that federally protected class, which I believe it's just everybody, because gender is just everybody, right? So you want to be very careful when there are incidents, when there are issues around those federally protected classes. In the absence of direct evidence, like a written statement by an employer that a particular employee was fired because of his or her gender, the following 4 things must be proven as to the case. Only 4 things. And courts all over the United States have been very consistent in checking for this 4 criteria. Number 1, the employee is a member of a protected class. Number 2, the employee is qualified and performing his or her job in a satisfactory manner. 3, the employee has suffered an adverse action such as a termination or lack of promotion. And number 4, the adverse action was the result of the employee's membership in a protected class. What I'm trying to say here is that for a staff member to bring a lawsuit against the company, and in this case we were talking about a discrimination lawsuit, for the employee to win in court, he or she or his or her lawyer has to prove the 4 things: that they are a member of a protected class, they are qualified in performing their job in a satisfactory manner, they have suffered an adverse action such as termination or lack of promotion, and the adverse action was the result of the employee's membership in a protected class. Now, if a court is satisfied as to the preceding requirement, the 4, the employer must then prove by records and other documentation that the adverse action was the result of legitimate business reasons. So avoiding discrimination lawsuits can be easy if you are aware of the law and you are prepared thereof. Therefore, right? So you want to make sure that all your business protocols, procedures, policies are well documented and available to employees. I would say the best way to avoid this kind of lawsuit is to always document and retain records of employee reviews, poor performance, and tardiness. In other words, if the person is constantly late at work, that's how they call it, tardiness. All right, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are continuing our conversation today around the 5 common workplace lawsuits and how to avoid them. Number 2, wrongful termination. Now, unlike discrimination and in some cases harassment, wrongful termination is not an actual cause of action upon which a lawsuit can be filed. It is really, generally, courts have decided that it is a blanket term used to describe various causes of action, both direct and indirect, that result in the wrongful termination of an employee. So what I'm trying to say here is that for most employees in the United States and Canada, employment with a particular company is at will, right? So there is no guaranteed, so the employment is not guaranteed pursuant to a contract, is at will. So unless there is a contract, either written or implied, that guarantees continued employment, an employee must prove that the basis for the firing was illegal. So this could include, for instance, violation of public policy. It could be whistleblowing, breach of fair dealing or good faith, or fraud, among other reasons. So the burden of proof has to be upon the company. So accurate and detailed records about the employee performance, the employee discipline, employee-employer communications. So this could be emails, snail mail, so paper mail, or text message, and so on and so forth, and also voice communication, and so on. All of those things can help an employee prove in a court of law that the termination was legal and defend against claims of wrongful termination. All right, so this is really one thing you have to really think about if you are a small business owner and you are sort of concerned about this kind of wrongful termination lawsuit. Let me just quickly recap it for you. You need to take, here are the steps you need to take, some of the steps, because every situation is different. But here are some of the general steps you need to take to treat your employees fairly and mitigate the risk of these lawsuits. So you implement systems to accurately track hourly employees' time. You want to develop, distribute, and review an employee handbook. This is very important. You need to work with your HR department to develop, distribute, and review an employee handbook. At a minimum, courts have instructed parties that the review has to happen at least every 6 months or maximum every year. You want to review the handbook. You want to keep detailed records of employee performance, discipline, and communications. Although these suggestions don't guarantee that employees won't be treated illegally or unfairly, or for that matter, that an employer won't be sued, they can really help you. They can go a long way to prevent some such problems. All right. So we're here talking about prevention here because, as you all know, as the saying goes, an ounce of prevention is worth a pound of cure. Right. Instead of spending millions of dollars in a court of law, you would rather spend a few $100 and have the proper framework, the proper procedure, the proper platform for documenting employee performance, discipline, and communications. All right. So number 3, here we're talking about 5 common workplace lawsuits and how to avoid them. I've already given you 2. Let's go to number 3. Number 3, personal injury. Before I do that, before I develop more, I elaborate on the personal injury part. If you love the content's clarity and quality so far, I would strongly advise you, and that will make me really happy, to smash the like button, to comment below, let us know your experience, to share this content, and most important, to subscribe to our channel and turn on the notification bell so you are informed whenever we drop a new show. And we do this every single day, rain or shine, rain or shine. So number 3, personal injury. Now, personal injury is basically an employer's nightmare. If you're a small business owner and you have such a lawsuit brought against you, you are literally, you'll be in it for a while. The truth is that most often than not, those personal injury lawsuits are quite preventable. Companies may be held liable for injuries that an employee suffers while at work, which are the result, at least in part, of an employee's negligence when acting reasonably within the scope of his or her employment. What I'm trying to say here is that for the court to accept the personal injury lawsuit and allow the employee to win, he or she has to prove that he or she was the injury was developed during the course of business, normal business, and that the employer was negligent in part or totally, right? So this sort of scenario might seem like a no-brainer and something easy to prevent, but consider that in a few years ago, there were more than 3 million recordable instances of workplace injury. Think about it, 3 million. 3 million. And now, as of the date of this show, 2020, we're talking about 4 million. And to 4 million recordable instances of workplace injury in the United States alone. So workplace injury can and do happen. This is just part of the operational routine that companies have to go through. Now, often claims of on-the-job personal injury are covered by workers' compensation insurance, which is why you need to get that. If you are a small business owner, you want to get compensation insurance. I believe that 45 out of 50 states require it. It's a requirement. It's a regulatory requirement, right? Because compensation insurance prevents an employee from seeking damages in excess of the payments received pursuant to workers' compensation insurance. So in order to avoid such lawsuit, employers need at a minimum to carry workers' compensation insurance and to respond promptly to safety issues communicated to the employer. Besides, an employer should diligently track all safety hazards, and this has to be done in accordance with OSHA guidelines. OSHA is the federal agency standing for, the acronym OSHA stands for Occupational Safety and Health Administration. Let me repeat that. Occupational Safety and Health Administration, OSHA. So OSHA has a series of regulations around safety hazards, and so you want, if an employer can monitor its adherence to OSHA guidelines, that employer can prevail in court. The employer must also follow the published safety guidelines and adequately train employees on workplace safety. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of the Awesome Sweetie Kiwi Show. We're still having a conversation here around 5 common workplace lawsuits and how to avoid them. Now, overtime is number 4. Overtime. Now, overtime can be really tricky if not monitored and tracked and properly understood, right? There is FELSA, is the Federal Labor Standard Act, is basically a federal law that governs, that sets forth, among other things, overtime pay requirements for non-salaried hourly employees. That's the key word here. The key phrase is hourly and non-salary. If you're a full-time employee, in most cases, overtime does not apply. So for a company to avoid overtime lawsuit, it should implement systems or processes that both properly and accurately track the amount of time that an employee has worked. That could be done very easily by having employees punch in and punch out, or having some kind of system where the employee has to log in into a web platform, and the web platform automatically records hours worked during a day or during a week or during a month or during a year. By making sure that these systems and processes are in place and working properly, an employer can rest assured that it has taken proactive steps to track the hours worked by the employees. Nowadays, it's getting even easier if you think about it, because there are apps, so you can track everything from your smartphone. If you're a small business owner, you can track everything from your smartphone, and I think the subscription costs somewhere from $20 or $50, depending upon the size of the business. And this is $20 to $50 per month, right? And you have the whole platform, the whole functionalities, that everything from HIPAA, in other words, health records safety, health records privacy, all the way to the internet laws, right? And they have to go, and this also encompasses the overtime regulations. The last common workplace lawsuit that we found in our research is harassment. So harassment doesn't necessarily require that an employee be a member of any of the protected classes, right? What I just mentioned earlier. But bullying or flat out hatred can apply to anyone, which is why harassment is commonly associated with membership in a protected class. Now, incidents of harassment can range from outright hostile statements or actions to benign statements or actions, right? So now the best way to prevent harassment and discrimination is by developing and distributing an employee handbook. And the employer has to be very strict in terms of formulation of the policies, and stricter in the implementation of the policy, in the enforcement of the policies, right? There has to be regular review of the content of the handbook by all employees, especially those whose jobs include employee supervision or management. What I'm trying to say here is that all managers within the company have to every quarter, every 6 months, or every year sign a declaration, sign some kind of statements where they are saying, listen, I've read this procedure manual, this employee handbook, and I agree that I have not done any of those, I haven't done any wrongful termination, I haven't harassed anyone, any of my subordinates, that kind of stuff. So an employee handbook should not only set forth the harassment rules and guidelines, but also should provide a discipline to those who violate such rules and guidelines. So if you have the employee handbook, and you have some kind of quarterly certification or biannual certification by those in charge, your company should be able to avoid any harassment lawsuit. All right, folks, thank you so much for listening to today's conversation. I really appreciate it. Let's quickly recap the 5 common workplace lawsuits and how to avoid them. So those five lawsuits are discrimination, wrongful termination, personal injury, overtime, and harassment. All right, I will talk to you another time. Thank you so much for your attention, and until next time, remember, stay marvelous.